Well, Natasha, many thanks for you for having me here in this virtual conference. And now in the next following minutes, I will talk about market abuse compliance in practice. And when I listened to the previous presenter, I had the idea, well, this is pretty much more down to earth and really a bit something what our clients are facing nowadays. It's not looking into the future about what is EU Listing Act maybe about, but really something about what is market abuse compliance in practice. And I would like to start right away. And we will have some three main topics, general aspects, most relevant aspects, as we cannot touch upon every aspect of market abuse compliance and practice, and some key takeaways. And just let's start right away with the general aspects, which should probably be very well known to all of you. And to be very transparent in this audience, as I am a German lawyer practicing in Germany, I will always focus on German listed clients, and that's why this presentation in a way is a bit about German practice of market abuse compliance. However, market abuse regulation, of course, is binding in its entirety and directly applicable in all EU member states. However, and that sometimes makes it a bit complex, national supervisory and national regulatory authorities and national criminal and regulatory law applies in addition, in a way, as another layer on the market abuse regulation. So for all the issuers, which perspective we now take for the next few minutes, it's already quite a complex framework. It's not only about market abuse regulation. It also covers, at the time being now, 17 EU regulations, additional national law. At least in Germany, we do have the German Securities Trading Act. And of course, we know all that ESMA issued guidelines, and our German authority issued the so-called issuer guidelines and some frequently asked questions overviews too. And all these regulations, texts, and so on, they all have to be complied with and always have to be checked when it comes to market abuse compliance. And the compliance aspect on this is, in a way, a process that's being established at the issuer, and it's necessary that this process is well functioning and at any time proper in place. In Germany, we do have what we call the Institute of the Auditors, and they issue kind of audit standards. And this slide is a bit about the general compliance management system. So it's not specific for market abuse, but for any compliance management system. It's audit standard 980, but in a way it is pretty much easy to apply on any kind of legal requirements. It always starts with the legal monitoring of compliance risks, and to analyze such legal risks. The next step after the issuer, or the issuer with the assistance of the legal advisor, monitor it and analyze the risk, then is to establish a compliance program. It's about document management. It includes the establishment of policies and instructions to certain employees within the issuer. And it's always very relevant that we do have a compliance organization in place, which defines tasks and responsibilities in particular. And not only having that task and the responsibilities be defined, but compliance is pretty often very much about communication. It's about training, of course. It's the question of how can we explain to the relevant employees in the company what is really important. And of course, in addition, there is a advisory function. So in general, we do know that issuers have certain employees taking over kind of an advisory function if the employees do have questions on the application of certain laws. If we have all this in place, then it still comes to further monitoring and improvements. So compliance management is always something, it's like a process being always on the road. It never ends. It's an ongoing process with audits and improvements, if any are available. And what is important, like the tone from the top, it's about compliance culture and goals. They need to be defined in a, for example, code of conduct, or how you name it. Sanctions and incentives should be set right and should be communicated clearly. The same is true for KPIs. So if we have this compliance management system always in mind when talking about the specifics of market abuse compliance, then it's, I don't say it's an easy one, but then we know the framework of how we can set up market abuse compliance from an issuer's perspective. And of course, there are several topics in MRR. I don't have to tell you, but there are very important ones, which is related to insider prohibitions, insider lists, disclosure of inside information, which concerns many issuers very, very hard, and then about managers' transactions. Let's start with the insider prohibitions and the insider law for issuers. Just to recall this very shortly, what is inside information defined in Article 7? It's an information of precise nature relating to issuer of financial instruments not being made public and likely to have a significant effect on the prices of the financial instruments. And from the issuer's perspective, in general, we focus pretty much on the shares of that issuer being listed. However, that's of course not the only financial instrument we have to always analyze in our compliance system. So if we start with the insider prohibitions, what does it mean from a compliance perspective? Of course, first, it is really important to communicate very clearly what is prohibited, and that it's not only insider dealing, but it covers recommending and inducing other persons too. And of course, the unlawful disclosure of inside information. So insider prohibitions always means for the issuers 3 parts of that, and all are very important. What kind of compliance measures are often taken by the issuers? It's an establishment of process and rules. And what is really important is to establish the need to know principle. And that is something sometimes a bit difficult to understand from the employee's perspective, that the need-to-know principle does not only apply vis-a-vis somebody from the external side of the company, but even within the issuer, and that not every colleague is allowed to get access to inside information. So it's relevant to enable the employees to limit such access to inside information. And of course, that is something so general and so important for the issuer that these compliance measures in general are addressed to every employee in the whole company, meaning the whole group. And by this meaning, sometimes all around the world, not only the legal entity being situated here in Germany or EU. How do issuers enable such processes? In general, they issue group-wide policies covering market abuse aspects. They are in general very issuer specific. Of course, there are kind of market standards, but it depends very much on the issuer at hand. If these group-wide policies are very extensive, or if they try to make it short and clearly. It's relevant to have these main documents to be kept on a central place, and in general this is the intranet of the issuer. Such documents and policies in general are regularly updated, and training is in general on a 1 or 2 year basis repeated, depending on the question how close the relevant employees are to this topic. Because we know from the compliance perspective that it's really relevant and helpful to have these trainings be repeated, to hear them regularly again, so that it's really something which the employees do have in mind. Such group-wide policies in general state a contact person in the company for any questions, and so that the employees are able to ask questions if any arise, and if they want to be on the very clear legal and lawful side. Special attention in generally needs to be paid in certain situations with respect to insider prohibitions. In Germany, it is pretty often that the issuers have employee stock ownership plans in place. They are a good instrument to set incentives to the employees to invest in the company they are employed at. But of course, such programs in general have certain trading windows or buying windows where employees may sign up or exactly buy shares of the issuer. Then it needs to be very clear that only persons are allowed to be part of the specific program if they are not an insider at the time they take their decisions. Quite common is to establish voluntarily quiet periods before financial reporting, and that is something that issuers on, and I want to emphasize this, on a voluntarily basis, in addition to the closed periods set out for directors' dealings. And they, of course, are company specific, so no general statements can be made on how they work in practice. But what is pretty often is that they apply to every single employee in the company, not only the ones who directors, dealings, managers, transactions would apply to. And sometimes they do cover a bigger time period than the 30 days of the manager's transaction. And all this needs to be set up in compliance documents and policies in general, group-wide. The next part we would focus here are insider lists. And insider lists in a way are very much more specific, and the regulations do not apply to so many, or are not of that relevance for so many employees, like the trading prohibition. It's on the first step an issue and a duty of the issuer to draw up a list of certain insiders. It's not about every insider, but it's about people who the issuer know and who are working for them and who have access to inside information. The issuers are required to promptly update the insider list, and in case of a request, provided to the relevant regulator. What does that legal duty mean in practice for the companies? Again, they have to take compliance measures. In general, they put in place sample documents and explanatory notes on how to set up an insider list. It sometimes sounds easy, but in practice there are many pitfalls one should try to avoid, and it's really not that easy to fulfill the duties for the insider list. And therefore there are often clear instructions for drawing up and updating an insider list. And in particular here in Germany, we have some companies in the market, some specialized service provider who invented, if you want, some kind of software and app for monitoring tools, because of course it's one of the challenges to monitor the reactions. If you include a person in the insider list, you are requesting certain information which in general you don't have even at the HR department, and you have to monitor the feedback. Does it come at all? Does it cover all aspects you need? And with some specific software which is available in the market, it's easier for the companies on the one hand. On the other hand, of course, it's quite costly, and of course not required by the market abuse regulation to put in place such specific tools. But of course it helps, as the regulation requires, to have an electronic insider list. You might use, for example, Excel, Microsoft Excel as a software for that, but in practice that is pretty difficult always to fulfill the requirements for the list within Excel. Just to give you an example, what the challenges are is that the authority may ask for a certain insider list on a specific date, and that would require to save a new file of the Excel insider list every single time then you make a change. Otherwise you cannot re-establish a previous status quo of the previous insider list. So the tools really make sense to use them, even if they are quite costly. And in practice, it's not that easy as it seems from first sight to always have it accurate, up to date, with complete data in the insider list. For example, the German regulator takes the view that not only the general resident address of the person included in the insider list needs to be stated, but if there are several places of residence, each of them needs to be included in the insider list. And sometimes it's difficult to explain that to persons included in that insider list. And sometimes I can tell it's a kind of a, I would say, bargaining of how much information you get on the first request. Some insiders are really thoughtful and concerned about giving private data in the required amount to the person who is keeping the insider list. So it's really not an easy job. It's really administrative and it's really burdensome. That's why I am talking a bit longer about insider lists than maybe one would do in general, but to really highlight and emphasize that is not something you can do quickly within the last 5 minutes of your working day. And then, of course, it comes to the disclosure of inside information. And in a way, that's, of course, a field of my heart and I close to my heart, and I really love this topic. However, it's not, again, the easiest one for issuers. The principle is that an issuer shall inform the public as soon as possible of inside information which directly concerns that issuer. Sounds easy. What does it mean in practice? Well, it of course means that you may delay the disclosure of inside information. And as we speak here, we know that there is a new draft under discussion, which in particular touches upon the disclosure of inside information within the EU Listing Act. And hopefully that will give some relief to the issuers, because it's really tough to fulfill it. Some issuers say, well, without legal advice from a law firm, it's just not possible to do. And maybe the regulator should think of, is that the right way, that you need always legal advice? Of course, I do like that idea, but maybe that should not be the principle of the EU to take this view. What you really need is a comprehensive documentation in case you want to delay the inside information, the disclosure of the inside information with, I don't say hundreds, but really some dozen information pieces on who is responsible for what at which time exactly, meaning not only a day, but the hour and the minute on the decisions. So such documents in practice are easily some 10-15 pages, and that's for some smaller issuers, and we do not have we should not only have the big ones in mind, but even the small ones. For them it's really burdensome, and you need to finalize the documentation timely, because in Germany we have the requirement that at the time we disclose the inside information, such documentation on the delay must be ready and at the same time need to be sent to the German regulator. So if you have successfully decided on a delay and finalize your documentation on the delay, you still are not done, but you need to monitor the future complying with the requirements to delay the disclosure, which means in particular that you as the issuer, in general, it's the investor relations department at that issuer, monitors press and other market reactions. Do they see certain share reactions, something what is unusual, and so on, to be on the safe side that we still comply with all the 3 requirements to disclose or to delay the disclosure. Important to secure at any time, and again, that sometimes sounds easy, but in practice it's a challenge too. The German view is that we have to disclose the inside information as soon as possible if the delay requirements are not fulfilled anymore. And this may happen 24/7. So in general, there need to be people accessible at least and available to monitor, and in case requirements are not anymore met, then disclose the inside information ASAP. By using a disclosure tool, these people need to have login data and so on, and they, of course, they need the sign off from the executives of the company to publish it. They may not publish it on their own. And so in particular, the availability of authorized decision makers sometimes, and in practice, and we are talking here about practice, is not that easy too. Just to give you an example, in Germany, we always talk about the executive board who would need to take such decision. And of course, these persons may not be available 24/7. Sometimes they are on a business travel, on a plane, on whatever. And so that in practice is relevant to organize for the whole time period of the delay, to have some decision makers at hand on very short notice. So what does that mean for the process, for a typical process of a delaying disclosure of inside information? We start in the compliance management again, and maybe I may recall the compliance management system. It's about a process and of course about operational instruction of whatever in general called disclosure committee. Sometimes it's an ad hoc committee or how you name it. And that committee, which in general consists of the, for example, compliance officer and the heads of regular involved departments. And to give you an idea what that means in practice, it's sometimes in general, it would be investor relations, accounting, depending on the nature of the inside information. For example, if it's about financials, it's the communications department, controlling, strategy, sales, head of legal, only to name a few. These committees, they would draft documents on the first incident and put together the facts at hand. What is the status of the inside information? Are the requirements to the delay process already met, or is there something that needs to be done about that? The task of the disclosure committee are to cover evaluation of the information and of course receipt of that information. A process needs to be in place that information will be passed through to such committee. And then, of course, it depends on the analysis, depending on the quality of the information the committee is evaluated. If it's not an inside information, if it does not qualify as such, then from a documentation and compliance perspective, it's always useful to put down some notes or a kind of a memo to document that the issuer has been aware and made a decision on the analysis. If the information they analyze qualifies as inside information, then the board documents will be prepared, which means the text of that disclosure of the inside information will be prepared in general in 2 languages. In Germany, of course, it's German and English too, and then pass it through to the board and require ASAP a decision of the board. If the committee thinks that the inside information qualifies as such, but a delay is possible under statutory law, then again they prepare all the documents for the executive board together with the explanatory statement of delay, and that's again the extensive documentation with draft of ad hoc proposals which are passed through to the board so that the board may take a good decision on all information at hand. And something that is a bit special in Germany and which is set out in the German Securities Trading Act is in case we analyze it's an inside information, we will start the disclosure process. However, we are not allowed to disclose it in the very beginning, but we always have a so-called 30 minutes waiting period. The 30 minutes are not set out in the statutory law, but that is what the German regulator and the German Stock Exchange would expect for. At the beginning of such waiting time, the inside information is processed to them. Then the issuer waits for that 30 minutes, and this period shall help the regulator as well as the stock exchange to take measures to help the market. For example, if it's really a very important inside information, for example, on an insolvency case, then they may stop trading and they probably need some time for this decision, and that's the 30-minute waiting time. If the issuer uses the typical tools, then there is kind of a countdown which counts down 30 minutes, and after that 30 minutes, it's automatically published in the internet and then actively be spread to market participants. So that was a very quick run through insider compliance. And as a last topic, I would like to speak some short minutes about managers' transactions, because they are of high relevance for German issuers too. Of course, you know that managers' transaction stands for the duty to notify transactions by persons discharging managerial responsibilities as well. And now the text would have been too long for that slide and for the heading, as well as closely related persons to such persons discharging managerial responsibilities. With managers' transactions, again, it's a bit special because it's not only the market abuse regulation the issuers have to comply with, but there are 2 other EU regulations. There are ESMA Q&As in place. There are, in Germany at least, German regulator FAQ in place, as well as the issuer guidelines. And then in general, there are compliance documents at the specific company, some operational instructions, which means if you try to analyze a certain topic, and if it's not a very standard one, a standard case at hand, then you need to run all through these regulations to check whether and how in particular a disclosure is required. The persons addressed by managers' transactions are the persons discharging managerial responsibilities. In Germany, we always say that this is, or these are the members of the executive board, as well as the members of the supervisory board, as we do know the 2-tier system in general in Germany. In general, we take the view that more persons are not discharging managerial responsibilities at an issuer, so it's only on the board's members, but for each board member, again, it's persons closely associated with them. And of course, the company is addressed by certain requirements the MAR sets out. What do we know if it comes to a trade, for example, in shares? We have the period of notification, and one of the changes of the market abuse regulation really helped a lot to say something very positive about the EU regulator. In the first instance, we had a notification period which was difficult to comply with. Now it's a bit easier. It says the person who is required to make the notification needs to do that ASAP, at the latest within 3 business days after the date of the transaction. And the second deadline now starts only at the time of the notification is received. Previously, we had the same starting date for the issuer, which made it difficult to comply with, to publish the director's transaction if the issuer received it kind of way last minute. And now the 2 business days after such notification really helps pretty much. But that's not all. It's not only about the transaction itself. The issuer needs to keep a list, at least so far. The EU Listing Act is probably amending that requirement. So the list to be kept by the issuer who are subject to the reporting requirement. And in such list, it's not only the persons discharging managerial responsibilities, but it's too about the persons closely associated with them, which needs to make it, which requires that each manager disclose in a way its private life to the issuer, even in case if there are never any transactions planned or ever executed. The issuer's duty is to instruct the managerial personnel about their responsibilities, and in turn, the managerial personnel duty is to instruct the closely related persons on their requirements. And now the next bullet is about the 30 days close period. I just talked some minutes ago about the quiet period under insider law, and one must not mix that up with the close period for managers transactions. And this is a the time period set up in the regulations. It's nothing that is specific for the companies. It's a 30-day period before publishing financial statements, which are required to disclose under national law. The interesting part of managers' transactions, and this is in a way something like the employee share plan, managers' transactions apply to elements of remuneration of the board if they are paid in shares, and that sometimes makes it not easy. Of course, in general, we want managers to be invested in their companies, to take share in the company and their success. So it's something what people want, but on the other hand, they need to publish potential transactions under the remuneration plan. And of course, from a compliance perspective, there's again instructions to safeguard that all the regulations are fulfilled and are in place. Having talked pretty much about compliance measures in practice, what are the key takeaways? It is about, the compliance system is about enabling processes. It requires company-specific solutions on top of the statutory law requirements. And of course, it includes various aspects and is an ongoing process. It never ends, just the opposite to my presentation, which would end here, but I'm happy to take questions if there are any.